Now, on matters corruption, which is at the heart of our constitutional order, if there is one item that frustrates the realization of this constitution is corruption. Clearly an unconstitutional conduct, and it strikes at the heart of the ideals of the people of Kenya as expressed in the current constitution. It is anti-people, and it is an existential threat to the sustainability of Kenya as a modern democracy. I dare say, from us in the national security space, we consider corruption as an existential national security threat, because it has the capacity of paralyzing all our sustainability arrangements in the economic, social, and other fronts. Now, allow me, I will not speak for too long, just allow me to say maybe two other things that tied to the fight against corruption. And I would want us to start thinking that we should, as a country, start shifting from fighting corruption as just a vice, as a moral vice, but look at it as a national security and national sustainability threat. Number two, the centerpiece of our constitution is the Bill of Rights. Is the Bill of Rights. And this Bill of Rights is the most, I think, one of the most progressive, putting together all the three generations of fundamental rights and freedoms together, which many countries have avoided. A constitution with enforceable socio-economic rights, which are supposed to improve the livelihoods of the people of Kenya. So corruption strikes at the heart of the constitution because it undermines the realization of the Bill of Rights, especially the socio-economic rights that are so central to this constitutional order. So as we deliver services, as we become accountable individually and collectively to the people, the fight against corruption and upholding the Bill of Rights, if you ask me, are the two matters that form the crown jewel of the realization of a better country. All of us exercise donated power. It's donated by the people, and therefore we are accountable to the people, and nobody is immune. Elected officials, appointed officials, all arms of government, all agencies, we are all accountable to the people and not to other, not necessarily to each other. And this leads me to argue that our accountability is both individual and collective. Because we are all creatures of the constitutional order, we are accountable to the people. That accountability is individual per institution. The executive is accountable to the people. The legislature is accountable to the people. The judiciary is accountable to the people. All agencies established under the Constitution are accountable to the people. That accountability is individual. But looking at the structure of our Constitution, that accountability is also collective. It is collective in the sense that while we owe individual institutional accountability to the people, we are collectively bound to work together to deliver that accountability if the Constitution is to be realized. And one of the constant areas of debates when talking about the connectivity of the constitutional order and the connectivity of arms of government and the collective accountability for all of us, one of the issues that have always dominated discussions is on the issue of independent offices and independent institutions, including the judiciary and other offices which are independent as created under the Constitution. And leads me to say and to submit that the same Constitution that requires us to be collectively accountable to the people requires us to work together, and that together, working together, is for all of us, including independent offices and independent institutions. How do we deal with the tension between the fact that the institutional independence, which is a bedrock foundational principle of our Constitution, does not lead us to working in silos and therefore defeating the collectivity of our accountability? We have had institutional confrontations between levels of government, between arms of government. The institutional confrontation between levels of government, fortunately for the judiciary, does not affect them because judiciary is not devolved. But you have a devolved executive at the two tiers, and you have a devolved legislature at two tiers. But the judiciary is power and mandate is exercised at the national level only. But even at the national level of government, there has been institutional confrontations, sometimes bordering on competition. I would want to suggest that unless we look for ways of working together, no single arm, no single organ can deliver. And I can say that without fear of contradiction. Because the same Constitution that has given you the massive powers you have has also donated some power to another arm of government, another agency, and it's deliberate. It is a deliberate constitutional arrangement. The same power that gives you that power from where you sit gives another agency, another arm, another level of government different powers. So unless we work together, we end up frustrating each other. The executive will make certain decisions based on the space that they occupy. The judiciary will also make their decisions based on the case of the space they occupy. And unless there are ways of, within the principles of independence, agreeing how to work together, we end up frustrating each other. Both the executive and the judiciary relies on parliament for appropriation of budgets, for example. So if we were to demean, for example, or to look down upon the legislature, the potential of the legislature frustrating the executive and the judiciary is real. And they will do it actually within the law, because the law doesn't say that you must get all what you want. There's no law that says you must get all what you want. It says other things. It says other things. Yeah. It says you must be facilitated to operate within the available resources.